The Renters' Rights Act has finally taken effect, bringing in a new age of landlord and tenant relations. But is there a clear winner? And if you're becoming a landlord for the first time this year, what do you need to start thinking about now in order to make sure you're meeting the legislation and navigating any disputes which may arise? Hi, I'm Cal Berendt, and welcome to RWK Goodman's Legal Thinking podcast, and a series on the changing landscape of property investment. Joining me to talk about these points is Leanne Bowler, a senior associate in our property disputes team, and Oliver Chandler, a senior associate in our residential property team. Welcome to you both.
Thank you.
Hi, thanks for having us.
Ollie, I'd love to start with you if that's okay.
Yes. Yes.
When it comes to overseeing a property investment, what are some kind of common regulatory considerations landlords need to be aware of?
So I suppose we need to consider whether it's a landlord that is new into owning property for that investment perspective, or whether they are someone who's a bit more established and they have already a portfolio. So with landlords that are looking to build a portfolio, the regulations that I think the most obvious and key one at the moment, of course, is the Renters' Rights Act, and understanding that buying properties at the moment will, with new tenants or existing tenants, it's slightly more interesting now, and you have to be a bit more on top of and understanding exactly what your tenants look like when you're buying that property. And actually, on top of that, you need to be very careful and aware of how well your predecessor, so the person that owns the property beforehand, how well they've managed the property whilst they have that tenure.
Absolutely. You mentioned the Renters' Rights Act. I mean, I guess for anyone who's been living under a rock the last 6 months, obviously it's taken effect in April of 2026. What's kind of the background of that? What has led to this act coming into effect?
So it's a good question. I think there's a perception that landlords have been slightly sluggish and lackluster in what they've been doing. I think that smaller landlords and those that own property for the perspective of just an investment, I think sometimes it was considered quite a passive role. You'd buy a property or inherit a property with a tenant in situ, and you would sit back and take the rental revenue and do very little else. Whereas I think the Act seeks to professionalise those landlords and tries to ensure that tenants are being looked after in the correct way. Whether that pendulum has swung a little bit too far is the big question. And we're still seeing what the ramifications of the new act are at the moment.
Absolutely. Leanne, I'd love to bring you in at this point. In regards to the Renters' Rights Act, I guess, what have been some of those core changes that have been brought in from a disputes side?
I mean, there's lots of changes. It's quite a sweeping piece of legislation which really changes the landscape, as Oliver said, about how things work in the rental market, with an aim of, apparently, I'm not sure it's supposed to just improve the situation of tenants, but some might say that it, as Oliver has said, the pendulum swung, and it does improve the situation of tenants quite significantly. So it makes it an awful lot more difficult. I mean, fundamentally, one of the first things for landlords to evict people. So before there was an awful lot of press about no-fault evictions. So landlords could give 2 months' notice after the fixed term, or when the fixed term was coming to an end, and evict a tenant on 2 months' notice. If they didn't go, they'd get a court order. The court didn't have a discretion about that. Completely changed. So now, the landlord has to have a ground, and the landlord has to be able to prove the ground. So if you want to sell, then you have to give the tenant notice, and you have to be able to show to a court that you actually intend to sell the property, and make sure that you don't re-let it in the meantime. There's lots of other changes. So you've got, tenants have got a right to have a pet, and unless the landlord's got a good reason for not providing consent for that. Trying to think of some of the more more changes.
So the rent is another big one, I think. So
Increases in rent. Yeah.
So rent, as opposed to being historically speaking, you would have your term come to an end and then you'd start a new tenancy agreement. Now there's a more regulated version of that rent review. So a Section 13 notice needs to be served, and on top of that, a landlord will have to justify that their rent increase is in line with market value. They can't go beyond market value, and tenants on top of that have a right to challenge that rental increase.
And that particularly is a really thorny one because it's quite easy for a tenant to challenge a rent increase, very easy. So they make an application to the first tier tribunal, and then the tribunal takes some time to consider it. The tenant doesn't necessarily need legal representation. And until, as my understanding of the legislation that currently is that until the rent increase gets determined, you carry on paying your existing rent. So in some ways, there's an incentive to start applying to the tribunal to challenge your rent because you can stay off a rent increase being implemented. And one of the things we've seen a lot more increasingly frequently in litigation is the rise of AI helping litigants in person. So add in, there's an incentive to challenge your rent because you don't have to pay the rent increase until the court decided it. And I think a lot of tenants are confident that AI can help them in court proceedings. So it becomes, worth a shot. If you don't like your landlord and they're proposing to increase your rent, then give it a go. And the court's limited as well, so the court can't increase the rent past higher than what the landlord's proposed. So before there'd be a bit of discretion, it could maybe not go in the tenant's favour, and the court could decide that actually the rent was even higher than the rent that they were opposing, whereas that's not on the cards, and that's not a decision that's open to the tribunal now.
It's really interesting that you mentioned elements in there around, obviously, tenants can now have pets if I guess it's reasonable, they can't unreasonably deny it. I imagine that kind of falls into this wider question of how the Act's impacted on property management for landlords, what kind of new considerations they need to be taking into account, what, I guess, additional hurdles, additional costs that are now coming in as a result of this Act. Are there ones to this degree, Ollie?
I think actually a point that we may have missed and that we should probably explain is that with the new Act, historically you would have assured short-hold tenancies, and your assured short-hold tenancy would have a term normally for 12 months. However, the Act removes that term and turns it more into a rolling contract. So I think that's a massive fundamental change, and that's where I mentioned earlier that landlords need to be aware of the tenants that they're, the new tenants that they have, and be confident in the tenants that they have, because as we've mentioned, it's difficult to remove tenants. So if you do have a problem tenant, you have to have grounds, and good grounds, and provable grounds or provable evidence for those grounds that will be a useful, or you can evict said tenant. So I think it's interesting and important to have that sort of fundamental point established, really.
I mean, as far as you can be aware of what a tenant's like, because I think a lot of these situations arise no matter how much vetting you do on a tenant. You think they've got the money to pay the rent and you think it's all going to be fine, but who knows what life's going to throw at anybody? You don't know what's going to change. So you think you can be the most diligent landlord and have got this great tenant, but their circumstances change, and that's life. And then you're at the liberty of being forced to serve your notice, and then the tenant doesn't leave, and then you're forced to go to court to evict them. And that all takes a really, really, really long time. And I know from a disputes perspective, there was a lot of discussion when the Act was first sort of being tabled about the prospect of how on earth the courts would cope with all of these evictions and all of these court orders needed. And it's not really an answer to that. So I'd imagine that potentially sometimes getting an answer out of the court can take weeks to a simple email. And I can't imagine that's not going to get any better without any investment. So if you're a landlord, it's going to take you potentially a really long time to get a problematic tenant out, which is a worry if you've got your income falling and you need to pay the mortgage. So
there's a really interesting point you made there about the courts being kind of more heavily impacted by demand for evictions. I remember one of the major kind of news elements that came around when this act was taken into effect was a pretty sizable increase in evictions right before the deadline. How, operating through that, how kind of was that?
I think it was chaos for our team for a little while because everybody was desperate to serve a Section 21 notice while you still could. It was a really busy period, and now I think round about now where we're reaching the end of the 2 months, so then maybe there'll be an influx in court applications over the next month because you can't issue your court proceedings until the tenant doesn't leave after the notice has expired. And then there's another deadline for when the court proceedings need to be issued off the back of your Section 21 notice. And after that, we then move into the territory of the new act and the new notices, and when they're served and, when those Renters' Right Acts evictions start. And then, I'd imagine towards the end of the year, we'll be looking at our first just sort of contested decisions under the Renters' Right Act where things have gone wrong.
Yeah, I was going to ask, how has that kind of fundamentally changed the eviction process now that kind of no fault evictions have been removed?
It does fundamentally change the eviction process because you need to have a ground to evict them. So you can't just evict somebody because you don't like them. And you've got to have, or because you want to increase the rent, or you've got to really think things through and be prepared in principle for a fight and for it to take a long time. And it can be difficult. Yeah, it's tricky. It's not only have you got to have a ground, but evicting somebody can also be quite tricky because you need to have all your ducks in a row, so to speak. So you need to make sure that you've complied with all the myriad of legislation to make sure you've got all your paperwork in place, because what we often experience is that things have maybe not gone quite right. Things like, I haven't done the gas check on time each year. And then that can be picked up as an argument to challenge an eviction at a later date. So you want to be as confident as you can that everything's lined up so that you don't find 6 months after you've served your notice or later and you're at a court hearing that actually you need to start again, because that's a really expensive process.
Imagine from a landlord's perspective, in that case, it's, as you said, having all your ducks in a row, making sure you've got, for the purpose of evictions, evidence, everything you need on that regard, but making sure in a property management point of view, you're maintaining everything as you need to do when you need to do it as per the legislation.
Yeah, and I think we were talking about this before we came in about how, in some ways, I think the whole sort of goal in some ways of the legislation is to professionalise the rental sector, and I think it does often perhaps leave you feeling like that is, if you really want to be confident of protecting your investment, then maybe professionalising it, getting an agent involved, or at the very least being involved in a reputable landlords association who can keep you updated on what you need to do, helps to protect your investment because you're confident that you're complying with the right steps. Because I think there's so many that it can be tricky to be fully aware of what they all are and what you need to do.
I think also with that is that some landlords need to be aware that they need to make sure that they're employing the services of a good letting agent. I think letting agents will also be massively impacted by the new act, in that because there's such a reliance on what they do and how they operate, those that don't operate so well will be very much under much more scrutiny. So I think it's quite interesting to see that side of things. But I also think that along those lines that we were talking about earlier, that it's interesting to see that you have smaller landlords will probably struggle that little bit more if they're not so used to being landlords or having to do those tasks on a daily basis. So I think the middle ground where you have someone that might own only 1 or 2 properties, well, I say middle ground, that's 1 or 2 properties is quite a humble start, but even up to maybe 5 properties, I think it's easier with scale to work with this regulations. And I think that maybe this is where we're going to see quite a lot of properties on the market, because a lot of these smaller landlords will just simply have enough of trying to keep on top of something that they aren't interested in, unless, of course, they have that good letting agent there supporting them through.
But you've also got to hold your nerve in order to evict your tenant in the first place to sell it. So that's part of the issue. So now that's why there was one of the reasons there was such an influx in serving Section 21 notices, because then you could exit the market. Whereas now you have to serve your notice, say you're going to sell your property, and then potentially go through the process. If you think your tenant's going to be tricky, you might want to wait until you've got your court order before you actually put it on the market, because a sale potentially is going to be jeopardised by having a tenant in situ you don't exactly know when they're going to get out, especially if the court backlogs are quite fast. So you've almost got to hold your nerve in that game.
Well, even with respect to that notice period, the Section 21 notice period was only 2 months. The new Ground 1 and Ground 1A are all 4 months. So immediately you've got a doubling of that initial sort of period. So again, and the impact of serving that notice and then not selling the property is that you can't rent that property out for a further year. So again, it does make selling a property a lot more risky. So
because you've got a void period, you've got 12 months potentially without any rent coming in, and you can't start renting your property out, because then you're potentially going to get a fine for abusing the legislation and saying you're going to sell your property when you weren't going to sell your property. But obviously that doesn't really reflect the reality of the matter, because you might put your property on the market, find that it's not attracting much interest, and not want to take a massive hit. That might be why you're not selling it, not because you were always, concealing the facts and trying to evict your tenant for no reason. But you see where that safeguard has to be in place. But equally, some people are honestly trying to sell and maybe change their mind. So
absolutely, it makes it sound like the Act is both a barrier to landlords entering, but also a barrier to landlords exiting in a way, because of these new regulations on both sides, making it obviously easier to more difficult to sell, and also more difficult in terms of the day-to-day management, I guess, of renters and tenants in general.
I do think it definitely sort of pushes towards the larger landlords. And I think that what I think potentially might happen, and again, this is me thinking aloud rather than and speculating rather than anything else, but I think that what we'll see is that some of those larger institutional landlords will buy properties at lower values from the smaller landlords, because they have tenants in situ and they're happy to take them on as they are and take the hit as such, but with a reduced sale price. So again, it seems to squeeze those smaller landlords further.
Absolutely. I guess there was a lot of noise made originally around when this act was coming through Parliament, that it's going to be a big win for renters in terms of it's going to be huge benefits for their own rights. Obviously, it's in the name, Renters' Rights Act. Is there any win for landlords in this act being implemented?
That's, again, it's an interesting question. And from a general perspective, it looks like a no, but I think it works well for those larger institutional landlords and those that are considering. I suppose what I'm trying to say is that for the individuals that are looking to join the market, they're not coming in as I'm a landlord. I as an individual own some properties. They are going to be companies. I have a property investment company, and that's what it will look like. The market, I think, is changing its perspective quite substantially, and I don't think you're going to have those individuals, and the individuals that do crop up, I think, are going to be those accidental landlords that have inherited property or possibly just weren't aware of the legislation and the difficulty surrounding it. So, yeah, I think you're going to see very few of those, but the larger landlords or those that are intending to scale up quite quickly, that's where I think you'll see more or they'll find more benefit.
Leanne, from your experience in disputes, is that something you agree with?
Yeah, I struggle to see a sort of win for landlords in any of this, because I see, we're used to dealing with the downsides of this, which is the, sorry, client, it's going to take ages to issue a claim. Sorry, client. No, I've not heard from the court for 2 months. I don't know where your paper is. So, I think you see the difficulties, because I feel like often in these kind of cases, I'm asking for things that people people just often don't have or don't know the answer to in terms of the documentation, and that's also critical. So I just think there's lots of burdens about like it that make things quite stressful for smaller landlords. And you're not the profits have been massively cut in other ways too. It's not just the Renters' Right Act. You've got the mortgage interest rates changing over the relief changing over the last few years, and you've also got there's other sort of double whammies, not just the Renters' Right Act and the in terms of the eviction notices or the notice periods for evictions, but also you've got selective licensing where sometimes you're whacked with a £1,000 fee just because you're a landlord in a certain area, and you have to also register to be part of the landlord database. So it just doesn't look like a great deal, does it? But it might, I guess the consequence of that is that potentially you free up more properties on the market, not just for institutional landlords to buy, but for people to buy. And maybe that rebalances the market generally, and you enable people to get onto the property ladder, because that is a problem, isn't it?
I think what's interesting about that is that you see that tenants need landlords. And I know that sounds like a very sort of silly point, but if you are finding a lot more tenants that are accessing these stronger rights, and they're quite happy to exercise their rights, and they're happy to
use AI to exercise their rights.
Fair point. If AI helps them contest their rent reviews and that sort of thing, I think the problem is that, and legislation is pushing it to some degree, that you will see less landlords, less people thinking that it's an attractive area to go into or to own property for that perspective. And it does sort of put pressure on people jumping onto the housing market, which sometimes people don't want to own a property outright immediately. They might want to rent as a couple to start off with to see if that works for them. And it'd be interesting to see further down the line. I'm quite a big believer in thinking about these things in 5 years' time. What will it look like in 5 years' time when, that early 20s sort of person was looking to potentially buy that property, or would have bought that property, but actually they're thinking now, maybe we should rent for a bit longer, or maybe actually we don't rent, we stay with our parents for even longer and try and, build up more capital to actually buy straight away. So I think it's an interesting set of thoughts as to where that potentially will go.
There's a really interesting point you make in there in terms of landlords and their investments. And obviously protecting their investments is crucially, at the end of the day, quite a core goal for many landlords. They want to make sure that investment stays standing and essentially is still valuable at the end of the day. What steps should landlords be kind of taking then to ensure their property is protected, both in regards to Renters' Rights Act changes, but also wider legislation and, I guess, changes in the current market?
I think the easiest fundamental step is to employ a good letting agent. I think that if landlords want to be active, that's one thing, but if they want to be slightly more passive, they want to have someone looking after the property for them to make sure that they're not falling into the various bear traps when it comes to trying to remove tenants. I think having someone in place that understands this is a good first step. When it comes to buying properties generally, I think it's, again, making sure that you are buying with vacant possession. And I think that, again, as we've kind of discussed already, you have to be very careful with buying with vacant possession, because it's a long process potentially. So you may start a transaction that you think will take, 3 to 6 months, but actually it's going to be an awful lot longer if you have problematic tenants that need to be removed from that property. So I think being slightly pragmatic in the concept that maybe, just maybe, this transaction will be slightly longer than they used to. So
there's always an option, I think, to make an offer to a tenant, and I think maybe that's where we end up. If the court delays or take a really, really long, if it takes a really long time, you want to sell your property, you're really struggling with that, then there is an option to pay them off and tell them to, they get some money if they leave and they don't dispute the process. And that's, maybe some tenants will be holding out for that. But so you almost circumvent the market and circumvent the statutory processes to get to the goal that you want. And then the question is, how savvy are the tenants? How difficult do they think this is going to be for me, and how much are they required to be paid off? But that is perhaps the pragmatic option sometimes. Yes. And I think also to go back to what we just said about how landlords protect themselves, the agent, I think, can be important. That obviously comes with a cut of the profits, but also insurance. So if you're going to serve a notice on a tenant, I don't think it's particularly unusual. If you've got a tenant who is a bit tricky and you serve notice on them, then they just stop paying the rent. And then you've got a really long time to get to court. And it's fine to say, oh, it's okay, well, I can get a court judgment against somebody because they've not paid me the rent for 6 months and that's X amount of money. But often sadly, it's not necessarily always cost efficient to start pursuing somebody for a court judgment. And if you're somebody who doesn't have a house, maybe don't have your own business and no intention of doing that, county court judgments aren't actually a threat or aren't seen as a threat to a proportion of our society. So, so there's no massive incentive to pay the rent. Maybe you could save some money for your next property and not pay the rent here. So insurance can sometimes help in that situation to help cover landlords for lost rental income. But you'd obviously need to make sure then that you're complying with the terms and conditions of insurance, which I don't think is necessarily straightforward in the legislation that we've got. So then we loop back to having an agent.
I imagine there's quite a good point in there as well, and I guess insurance probably forms part of it. Documentation for landlords. How important is that in terms of making sure that when disputes do arise or can arise, having the right documentation can help kind of mitigate some of that dispute?
I think it's really, 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 really important. And I think it's one of the first things that we'd check if we were asked to serve a notice. So we'd want to check with the agent, have you got your gas certificates? Have you got, if you served your information on the tenant, is the deposit, if there's a deposit, is that, is it for the right amount? Because that's another change introduced. There's limits on how much deposit and how much holding deposits you can get. Is it in the tenancy deposit scheme? Is it, all of those things can lead your notice later to being unenforceable, and then you can't get your court order. So the documentation is absolutely critical.
Yeah, I imagine that's probably one of potentially many pitfalls that landlords have to navigate when going through disputes to make sure that they can ultimately end up on the successful side when it comes to a dispute against a tenant.
Yes, you want to be confident when you serve your notice that your notice is correct, and then that enables you to have a conversation with the tenant, I guess, about the enforcement. I think the reality is that a lot of disputes that we see end up, in terms of evictions, end up going to court because of the policy taken by local councils. So you're serving a notice and you know that your notice is valid, and it's not necessarily always that useful to say, oh, I can talk to my tenant, I can do a settlement offer, because it does depend on who the tenant is. Well, that's an option for some people, because sometimes in order to rehome somebody on the council waiting list, the council insists that they've got a bailiff appointment. So they require the landlord to follow the eviction process through to the very end, get the court order, get the bailiffs. And at that point, they'll rehouse them, and they won't rehouse somebody until they've got the court order. So then getting the documentation is critical to make sure you get to the stage where you've got the bailiffs who are able to come.
And I imagine from a time frame set of mind, that could be months down the line.
I mean, I think that could easily take a year, especially with the slightly longer notice periods, potentially even longer, because you've got there's different players in the court, and you've got the claim needs to be issued. You can't issue the claim until your notice period is expired, and then you need to get the hearing. And then sometimes, the hearing might be adjourned. Sometimes you get hearings, it's like, we've got 10 hearings on this morning all at the same time, or then maybe there's not enough time for it to happen this morning because one of them's overrun, or maybe actually your tenants raised some issues at the last minute and the hearing's for 10 minutes, but this is going to take an hour to sift through what they've said. So don't worry, we'll push that off for another 2 months. And then eventually you get your court order if all goes well, and you've got to, then you're dependent on the county court bailiffs to come out with their eviction date. And I think if there's a lot of possession orders waiting to be enforced, the wait for a bailiff can be a number of weeks, if not longer. So it does end up spinning it out for a really long time.
Imagine at the end of the day as well, that all piles extra pressure on landlords who just want to protect that investment of property.
Yeah, extra stress, extra pressure, because you just don't, you can't, I think as a litigator, you find that really difficult because I can't give you a clear answer. I'd love to give you a clear answer of, oh, we've issued your claim and that's great. You get a court order in 2 months and then they'll go. But in reality, it doesn't often work like that. And as I referred back earlier to the impact of AI. And I think that can also help to spin things out, because you can sometimes come up with vaguely credible arguments that maybe have got absolutely nothing to them, but they still need to be given, everybody's got a right to be heard, and that's important, isn't it? So maybe that needs a longer court hearing to hear those arguments. And if you can persuade the court to give you a longer court hearing to hear the arguments, then it takes a lot longer to get it listed and a lot longer for the order to be made.
Absolutely. And I imagine with AI coming into the picture more and more through general use, that could potentially also impact on those timeframes as well. As you said, it gives people the right to be heard in a different way. They can put forward arguments that then need to be dealt with. And obviously that just helps accentuate the entire thing.
Yeah, and increases the cost for landlords of the eviction process, because you need a good lawyer to go through and dismiss all the arguments. And also, you'd hope you have a good judge. The judge is hopefully tasked with these things every day, but it depends who you get, who can see the nonsense and work out what's good. But because there's so much documentation, because there's so many steps that need to be complied with, and it does become easier to come up with something that can potentially thwart the eviction process.
Absolutely. Ollie, just to throw to you on a kind of, I guess, slightly tangential but probably separate topic. When it comes to that wider, investments kind of perception, rental and residential property is probably existing, not in a vacuum. There's obviously wider investments that can be made in terms of commercial, in terms of even those traditional cash funds and stocks and all that. Yes. For those looking to become landlords, how important is, I guess, diversification in their approach? Should they be putting all their eggs in, I guess, for instance, new homes or HMOs or anything like that? Or should it just be focusing on one specific thing they can do quite well?
So again, I think diversification is, as you say, I think that's fundamental. I think that no matter what you're looking to do to reduce your risk, I think it's a good idea to make sure that you're covering all bases. In terms of, whether new builds or the likes, I think that new builds are probably that little bit more attractive in one direction of EPC ratings, for instance. However, with new builds, you do have various snagging and all that sort of fun and interesting elements and points to consider. So again, there are quite a lot of ups and downs when it comes to these investment tracks. So sometimes actually it's more attractive to go with a slightly more aged and lived in property because it's been set up and it's okay. So previously you might accept that you have tenants already in situ in a property because that's quite attractive to some degree if you've got a good tenant and it's rolling on and you can keep that investment going and you're buying a live investment that will, hopefully you can be that little bit more passive with. But I think in this day and age, actually, you have to be incredibly active in confirming your investment and making sure that you're picking something that is sound. And I think the overall sort of points, though, is that I think being a landlord comes with a higher inherent risk these days. So it's just a case of accepting that there's a risk associated and, again, trying to offset that elsewhere.
You can try and mitigate that, I guess, as well, and touching on what you've said about the standard of the property. So there's new fines introduced, I think, last week if you don't keep your property up to the requisite standard to prevent tenants living with horrible things like mold and damp and so forth. But you want to, I guess, keep on top of that in terms of checking the property regularly and carrying out regular inspections to make sure that your property is in a good condition so that you're not going to get bitten by well, problems can get out of hand if people don't report them, and then they become expensive. And then you've also got the risk of fines if you're not acting reasonably enough in terms of remedying those problems as soon as you become aware of them. So, managing your property well and diligently to minimise the risks that might arise.
I think that's also important with the ombudsman that's kicking in as well. So again, I think that's another element that the Renters' Rights Act will impact landlords generally, in that they have to be somewhat more accountable to maintaining that property. So instead of being reactive, it's a good idea to be proactive and to, as you say, to proactively go check your properties, make sure that they are as they should be. And on top of that, documenting to make sure that, to tick the box that you have been to the property, you've seen what's what, and you know what's going on. So I think
that's going to help in the event of any dispute if you've documented things well and said that you went to visit and you've checked and here's a photo and here's what I'm doing about it because I've got a receipt, and then that helps you defend any spurious claims that could arise about the condition of the property.
Absolutely.
And those informal sorts of phone calls that you might get saying, we've noticed a small problem, even those need to be documented properly, because again, that could, especially actually the thing that I think is quite interesting is WhatsApp and various messaging, that's instant messaging that wasn't necessarily taken too seriously 10 years ago, but now I think is becoming more and more a fundamental documentations format. So
I've got cases where I've done witness statements where, I think one most recently where somebody was complaining about pest infestations, and you do rely on the WhatsApps they've sent to the landlords, and you see that the tenant says you haven't done X, Y, and Z, and you're like, well, here's my message. So can you counter that? So that does create a log, which can be helpful because we're away from pens and papers and files to just noting, you called me and I said that I'd do X, Y, and Z, or don't worry, the agent's coming around, or the pest control or the builder's coming around to have a look at things.
There was an interesting point you made in there about the, I guess, responsibility in terms of landlords, making sure they're attending the property, they're making sure that they're kind of having a look at those issues, so then when a dispute arises, they can kind of go down that road. Mentioning earlier as well, in terms of getting a good letting agent and having that involved, having been in rentals myself in the past, there's obviously that tension of landlords going, well, this is these estate agents, letting everything go through them, and then they kind of deal with that first. Is it probably now starting to become more of a case of the landlord should be taking a more proactive role? And how does that relationship with the landlord and the letting agent kind of look when it comes to making sure their property investments are protected?
I think the relationship between landlord and agent is becoming a little bit more fluid, in that you might have landlords that understand there's a responsibility that they need to cover and make sure is, ownership of that responsibility. Whereas I think previously you may have had a situation where you'd almost offload completely to the agent and, assume that they're doing as they should be. I can see there being a situation where landlords are a bit more proactive. They want to be involved. They want to make sure that certain areas and elements within the regulation are being sort of held up, whether that active landlord is just checking in with their agents more so, or whether that is them actively, dealing with certain elements themselves. I don't know. That I think it depends on the landlord, depends on their appetite to be involved. I
think it also depends on there's an element of risk in all of these things, isn't there? So if you're instructing a large national well-known name to be your letting agent, and you've got letting terms to say they're going to manage all the paperwork, maybe in some ways it's safer to step back and say, okay, get on with it, because if it goes wrong, then you've got somebody who can pay out to cover that. Whereas, if you're going to instruct a smaller letting agent who's much less sophisticated, potentially, not saying that it is, but potentially there's a higher chance of it going wrong, and potentially they're not going to necessarily pick up the bill if it does go wrong. So, that in terms of professionalization, that might push you towards a bigger name where you know that they're going to be competent, and there's less risk and the less likelihood of it going wrong. But obviously for that probably becomes a higher fee in terms of a higher cut of the rent. So
Again, it's that offsetting, isn't it? Which sort of how much responsibility compared with risk, compared with price. So again, I suppose it goes back down to money, doesn't it? Really, more than anything else.
What are you going to pay for? You get what you pay for sometimes. So.
Yeah, no, it's difficult, isn't it? You kind of want to be slightly balanced with these sort of things, but the regulation has swung a little bit too far, and it's hard to see the positivity. I mean, for you, I'm not surprised because you see
I see the worst case scenarios.
Yeah, whereas for me, maybe I'm slightly less negative towards the act on the basis that I can see larger investors being able to, pick up that market. And, maybe there is a small sort of sector of the market that wasn't run very well. And maybe that's actually, it's a good thing for that sector to no longer be landlords. And maybe actually the larger institutional ones will swoop in and take away those properties for a premium, and those and the loss of that smaller landlord might be a good thing. But again, it's difficult to tell at this stage, and it's difficult to, I suppose, you're hoping that investors will be good landlords and that maybe the reputation of big bad landlord becomes a little bit more positive.
Yeah, well said.
I think that's a really good point to end on, to be honest. So that's fantastic. I think we'll leave it there. Leanne and Ollie, thank you so much for your time. Really appreciate talking to you.
Thank you.
Thank you very much.
Thanks for watching this episode of Legal Thinking. For more information on the Renters' Rights Act, please check our article located in the show notes. For more episodes of Legal Thinking, please check here. And feel free to like and subscribe by clicking here. Thanks again.